Hi, it's my pleasure to welcome you on behalf of your training to this training program on intellectual property rights. This session will provide you a multidisciplinary overview of our intellectual property programs. We will be covering multidisciplinary aspects, performance level aspects related to utility patents, design patents, plant patents, copyright, trademarks, industrial secrets, and geographic indicators. We hope you're going to find this program very useful for your intellectual property related business processes and for your intellectual property related career. What is a patent? Patent is one of the intellectual properties. We'll introduce you to all the intellectual properties later, but one of the most common intellectual property is called the patent. So what is a patent? Well, a patent is a social contract with the inventors. The society enters into a contract with the inventors. And what is this contract? It says, disclose fully what you have invented, and we will give you by law a 20-year right called a patent to exclusively market and sell the product and technology. So in exchange for full disclosure by the inventor is given a 20 years right to exclusively market and sell the product. And after the 20 years, this technology becomes open for everybody to use. During the 20 years, public will have right to improve this technology and get patents for just the improvement parts. Anybody can use the patent info to teach new students, people during the patent period or the 20-year period. So the inventor discloses his invention fully. By fully we mean to a sufficient level of detail that an expert in this field should be able to put the invention in practice. And in exchange for such disclosure, the inventor is given 20 years exclusive right called the patent. Why do we need the patent? Why do we need such a contract? Well, for that, it will be educative to look at the historical aspects of patents. 500 BC, 2500 years back in Greece, in order to encourage innovators, they were allowed the profits for 1 year of their inventions. In 1331, in the UK, John Kemp and Company was awarded letters patent for innovations, but there was no systematic method. This company was given the first patent. In 1450, Venice started systematically granting patents for 10 years. So in 1450, inventors in Venice, after they disclosed the invention, were granted patents for 10 years. 1790, April 10th, first US patent law was passed. This patent law existed from 1793 to 1836. The award was, during this period, the award was without examination. So there was no check was made, no too much check was made about the invention itself. So 1790 in the United States. Then during the Industrial Revolution, industrial exhibitions became industrial revolution during the Industrial Revolution, exhibitions were held in places like Vienna, London, Paris, where the various companies and inventors would bring their new products and services for sale and for demonstration. And these exhibitions became fertile grounds for spying in the 19th century. Therefore, non-national exhibitors became hesitant. Now, remember, the patent is awarded by the country. Patents had been even today, patents are awarded by the national government. It's a social contract in the country. What about other countries? In the 19th century, foreign visitors to these industrial exhibitions would spy, copy the technology with the effect, and then they will go back to their own country and produce the same product. The impact was that non-national exhibitors became hesitant to come and demonstrate their products at these industrial exhibitions and trade fairs. Therefore, the 12 countries of that time, Austria, Germany, France, UK, they got together and they discussed the need for some sort of international treaty in that area. And the fruits came in 1883, March 20th. The Paris Convention for Protection of Industrial Property was signed. 11 members, countries from Europe and Central America, signed it. Today, the Paris Convention has expanded and it has 177 members. Almost every country is a member, except Burma, Ethiopia, Somalia, Eritrea, South Sudan, and some islands. China joined in 1984. Russia joined in 2015. USA joined in 2016. This treaty has been revised in 1900, 1911, 1925, 1934, 1958, 1967, and 1979. And today the treaty stands as it was signed in 1979, more or less. So at the international. So what does the Paris Convention? What was agreed in the Paris Convention? Basically, what was agreed was that if an inventor obtains a patent in one country, he is given 1 year time within which he can apply for patent protection in other countries which are members of the Paris Convention. And many other requirements are there, but the essential and the most important one in the context of what we have discussed till now was that if you apply for a patent in your own country, then the Paris Convention gives you 1 year within which you can also apply in other countries with the same priority date or the invention disclosure date. So in other words, if you apply for something in the UK, no competitor or others can steal your invention and apply in other countries immediately after that. Before you had an opportunity to go to, say for example, to go to Paris, somebody has already applied for a patent for that invention that you are disclosing. So Paris Convention, an important treaty, a very important treaty in relation to international patent rights. But in 1995, the TRIPS agreement was signed. TRIPS agreement under the WTO system. And TRIPS was one of the 20 agreements that were bundled together in the WTO, World Trade Organization. And the TRIPS agreement basically defined some minimum intellectual property rights that have to be given to inventors around the world in all member countries. It incorporated the Paris Convention in terms of patent rights, but it also put down things like that you cannot discriminate against foreign nationals who are members of the Paris Convention or the WTO in the grant or processing of patent rights. This TRIPS agreement came into force, was signed in 1995. China joined it in 2001. Russia joined in 2015 or so. The TRIPS agreement is the current minimum patent law in all member countries, and we are talking about 177 countries plus. So TRIPS agreement, an important agreement to remember to understand global intellectual property rights. Again, intellectual property rights are national rights. These are rights given to you by the laws of your country, of each country. Each country has its own laws. But what the TRIPS agreement does basically is require that all member countries must make laws in their own countries which must at least to a minimum comply with the what is mentioned in the TRIPS agreement, and they can give more rights to inventors. More rights than that have been given under the TRIPS agreement, but they cannot give less rights, and they must give the rights to all members of the WTO, and they cannot give preference of any type to nationals as compared to foreigners. We will go into all these details later on, but sufficient to notice at this time is that the Paris Convention and the TRIPS agreement are the current international, you can say, laws related to patent rights, which is one type of intellectual property right. But this is an introduction. The details we'll discuss later. And there are many, many details that one needs to know about to become a professional of intellectual property, or to be able to make sensible decisions in the area of intellectual property, whether at a corporate level or at a personal level. We will discuss all of these during the program. But continuing with our introductory discussion, let us take this issue about what would happen if there was no intellectual property right. Suppose there were no patent rights. Then what would happen? And when there were no intellectual property rights or intellectual property rights, including patent rights, what was happening? Remember the Egyptian pyramid technology? Even today, people are wondering, researchers are debating, PhDs are being written on how the pyramids were constructed. Why? Because whoever constructed the pyramids, or whoever had the technology for constructing the pyramids, never obtained a patent for it. If they had obtained a patent for it, they would have exclusive right to make pyramids around the world, but they would disclose everything about making pyramids, so that after 20 years of their disclosure, anybody could make pyramids anywhere in the world. It will be open knowledge. But no, in those days there was no intellectual property rights, so whoever made the pyramids, he kept the technology secret, or maybe kept it inside the family. And then maybe there was an epidemic, maybe there was a flood, maybe there's a war, and the whole family who knew about the technology died, and this knowledge was lost forever. And a sample of what happens if there was no intellectual property rights. The inventor would keep his invention secret, hoping to use it one day for his own personal gain, maybe even use it for his personal gain in business, maybe pass it on to his children and his family, and so that the children can benefit from this knowledge or technology. But then there could be a catastrophe and the whole family dies, and this technology is lost forever. Intellectual property rights prevent such things. They give the opportunity for the inventor to get 20 years of exclusive right in exchange for disclosing his invention. And the invention goes into public domain after 20 years. When you visit museums, you see beautiful 2000-year-old Chinaware, still beautiful today, still bright colors, haven't faded at all. How did those people make the colors or make those Chinaware? Nobody knows. There are many theories, many people have researched, but nobody is sure. Nobody can duplicate it. They're trying to use the technologies to try to make Chinaware even today, because there were no intellectual property rights. So whoever made those Chinaware never documented the technology for future generations. The Taj Mahal technology. The Taj Mahal was built a few hundred years back. Beautiful structure, wonder of the world. But nobody has been able to create such a product again. Not only because of the cost, but maybe because of the technology aspect and so on. There was no patent. Then there are the 1200-year-old Maya blue paintings, still bright today. Mayan culture in Central America. They made these blue colored paintings, and even today the colors are so bright. How did they make the colors? There's a lot of research on that, a lot of theories, but nobody really knows because it was never put in the public domain. It was never patented. Whoever was making them were keeping the secret closely guarded. And then somehow the Mayan civilization collapsed, and with it was lost this knowledge. There are many ancient cures or medicines being rediscovered today as traditional medicine, because many of these medicines were never documented in Africa, Asia. Again, if intellectual property rights had been there, these knowledge could have got documented. In short, without intellectual patent law, technology would be lost forever. Inventors would keep the technology in their families, then a corona-19 or plague or flood can wipe out the knowledge forever. Without international patent laws, international trade will become very restricted. New technology goods would not be exported from fear that they will be copied. So the law has therefore recognized intellectual property rights, and they recognize them early. And we can consider now the intellectual property rights almost like a social contract, whereby the inventor, he discloses his invention, and in exchange the law gives him certain exclusive rights for a certain period of time. So it's a social contract. To inventors, for example, you disclose what you have invented, unique new thing that you invented, and the law will give you 20 years exclusive right to use your invention and profit from the invention. And after 20 years, this invention will go into public domain. Anybody can use it. And during these 20 years also, people can study it. People can improve the invention, but they cannot make the improved part, without, if it requires using the original invention during the 20-year period. You can use the disclosed details about the invention for training programs to teach new students about the technology, even though you cannot practice the technology during the patent period. So these intellectual property rights that we are familiar with today is, if you make a new invention, you get a patent. And a patent, it gives you minimum 20 years protection under the TRIPS agreement. We will talk about the TRIPS agreement. TRIPS agreement is the current, we can say at this moment, is the current minimum intellectual property protection that has to be given around the world by every country. New literary works, books, articles, video, etc., you can get a copyright for them. The IP right recognizes the copyright. This IP right is given in exchange for your putting the creation into some physical medium, like on paper, like on video recording, etc. And this protection of copyright is usually given for a minimum of 50 years plus the life of the author. But this period may vary from country to country. Means countries may give more than 50 years after the life of the author. but not less than 50 years if they are members of the WTO, or they have to comply with the TRIPS agreement. Then there is also intellectual property that is given to businesses, or we can say to creative and quality producers. Certain intellectual property rights are given to creative and quality producers. These intellectual properties represent in the form of new industrial designs. When somebody creates a new design for a product, then 10 years he is given 10 years exclusive right to use that design. Design as different from invention is, the design aspect is only is some features which have no utility value, but only aesthetic value. If you create a new art or a drawing, you get a copyright, or software, for example, you get a copyright. Minimum 25-year protection, except Rome Convention. Trademarks. If you're a quality producer or a quality service provider, and you have put in a lot of effort in reaching that quality for your products and services, you would probably be having a brand or a trademark. And that trademark is protected like an intellectual property. Advantage which the society gets is that they are encouraging manufacturers, producers, and businesses to improve the quality of products and services that they are selling so that customers can benefit, or the public can benefit, and they can benefit from the certification. Another intellectual property right, which is really an exception to the social contract principle, is a right called the industrial secrets or trade secrets. What this intellectual property right does is it allows companies to keep their technology or data secret, and by law prevent people who are people from stealing that information. Stealing here meaning obtaining it in an illegal manner. So there is there any social benefit? I don't know. But this intellectual property right also exists. It's an exception to the other intellectual property rights actually. We will discuss these in detail in the subsequent parts of the program. Now let us look at, in the overview, the main sources of laws and treaties that regulate intellectual property rights. We said patent laws or intellectual property laws are basically national laws. Each country makes its own laws for patents and intellectual property. So if we want to understand what are the patent laws or intellectual property laws in any country, we have to go and read the laws in that country. That would be a very tedious job, right? 177 plus countries, or maybe close to 200 countries now. And we go and read each and every country's patent law to understand what are the rights inventors have, or intellectual property holders have. Oh, that's too much. But that's the fact. So what the countries have done is they have signed international treaties so that an inventor's rights can be protected in other countries also. Now imagine you are an inventor. You have invented maybe a very comfortable chair, and you have obtained a patent for it in the United States. If you start, once you have a patent, nobody can produce such a chair other than you, and or sell such a chair other than you in the United States. But what about in Europe? A visitor could come to the US or go on a website, see the design of a chair, and he can produce the same chair in China and sell it to every other country except the United States. So how to deal with that? And these type of situations have been dealt with by having international treaties have been signed. The oldest treaty was the Paris Convention, 1880s, probably 1883. 11 countries got together from Europe and Central America and signed the Paris Convention for protection, for providing patent protection or intellectual property protection to inventors in all member countries. So it started with 11 countries. Today it's 177 countries. 177 countries are part of the Paris Convention, which provides protection for inventors or a method for protection of inventors in every country of the world, provided they follow. It actually facilitates the inventors getting protection for their products, for their inventions in every member country that they are interested in. So the Paris Convention facilitates inventors in obtaining intellectual property rights in all member countries if they so desire, provided they follow certain procedures. The Berne Convention is about similar convention about copyright, international protection for copyright for books you have written, for example. And then in 1995, we had the TRIPS agreement was signed. TRIPS agreement was part of the WTO, World Trade Organization, or of a major treaty that was World Trade Facilitating Treaty, which was signed, known as the WTO. And one of the agreements in the trade deal was about the TRIPS agreement. TRIPS stands for Trade Related Intellectual Property System, which sets out the minimum intellectual property rights all member countries have to give to inventors. Again, TRIPS sets out the minimum intellectual property rights that member countries of the WTO must give to intellectual property, inventors, right holders, and so on. It also sets out that no country, no member country can discriminate against foreigners in the grant of intellectual property rights. Then there is the PCT, Patent Cooperation Treaty. Patent Cooperation Treaty. To understand the Patent Cooperation Treaty need, what it does is it makes it easier for inventors to get patent protection in different countries. Makes it easier. How it makes it easier is, for example, the TRIPS agreement and the Paris Convention. They give an inventor a right that if he files for a patent in any one country of the TRIPS agreement or of the Paris Convention, then he will have, or he will be allowed 12 months time to file patent applications in other countries, other member countries. So he gets 12-month time to file patent applications in other countries and getting the same priority date as of his original application, of his first application. So it makes it easier. So which means that somebody, and then every country will judge his patent application on its merits according to its laws and decide whether they want to award him the patent or not. Patent Cooperation Treaty sets up a friendly procedure for inventors whereby you file the patent in one country and you opt for international patent and pay the related fee, and you get your patent examined by a patent examining authority, and this will give you about 30 months in which you can file patents in other member countries or other PCT member countries. So instead of the 12 months time that you had before to decide in which countries you are going to file your patent, PCT, Patent Cooperation Treaty, now gives you 30 months to make the decision. So 30 months is a pretty good time in which one can decide the strategy one is going to have in relation to protecting his patent. So Patent Cooperation Treaty. And there are other treaties. There are many other treaties that we are going to discuss. Now, other sources of intellectual property rights include the national copyright law. Well, just like the patent are governed by, ultimately the patents are governed by the national patent law. Similarly, you may have a national copyright law. And that national copyright law will determine the copyright, the intellectual property related to copyright that has been given to writers and creators. Of course, if the country is a member of the Berne Convention, then it must comply with the minimum protection requirements that are allowed under the Berne Convention. Then every country has its own trademark laws, or we can say every country has its own national trademark laws, which talks about what you can trademark, how you must apply for a trademark, and what protection you are going to get, and what you need to do in order to keep the trademark alive. In the US, trademarks are also the subject of state laws. So every state has its own trademark law. And also there are federal trademark laws. So one has to have an understanding of both of them. Then you also have to look at industrial secrets law. related to an intellectual property, which is industrial secrets. So what are the rights given to businesses and industries to keep their proprietary information confidential? So industrial secrets law, we can say, is the right, gives the right to businesses or that allow them to keep their confidential information secret and protected. Now, the opposite to the intellectual property right is the anti-monopoly laws. So number 6 there is not really an intellectual property right enabler, or doesn't give you any intellectual property right. In fact, it takes away some intellectual property rights that you might have. Takes away some rights or prevents you from doing certain things. These are called anti-monopoly laws or antitrust laws or competition laws. Now, a patent by definition is an exclusive right given to the inventor. In fact, exclusive right means a monopoly is being created. The monopoly can be misused. So if somebody has a patent and his invention is really critical for society or for the public or for the customer, they would be ready to pay for it. Doesn't matter what the price. For example, pharmaceuticals. Somebody gets a patent for some medicine, and that medicine is a monopoly. So every patient who needs that medicine will be ready to pay whatever price the company is asking. So this will lead to certain acts that might be considered as antitrust or against competition, not allowing competition. So every country has its own anti-monopoly laws, which talks about what sort of things businesses cannot do, and if they do it, they will be penalized by law. So these are anti-monopoly laws. And then there are laws in every country regarding exceptions under which the intellectual property rights given can be taken away or can be temporarily suspended. For example, if issues of national security are involved, or there is a health emergency like the COVID-19, or it is in public interest to do that. In fact, the TRIPS agreement also has provisions which allows national governments to make laws for such type of events, and so on. There are many other laws and treaties that we are going to discuss, but these are the main sources of intellectual property law and treaties. There are many. Now, what cannot be protected by utility patents or by patents? So it might also be interesting in this overview to consider what type of things will not entitle you for a patent, even though you may feel that you have done something new or magical. For example, ideas. If you have an idea of a fantastic product, but you haven't done anything to document it, to prove it, then this idea is not patentable. It's not intellectual property. Somebody steals that idea and goes ahead and does the spade work to get the product which would come out from the idea, that he will be perfectly within the right. He is the person who is going to get the intellectual property right, not you, even though it was your idea. So ideas cannot be patented. Inventions that are not new. If you invent something which is not new, then you cannot get a patent. Well, obvious. So when we say not new, it means any invention mentioned in any previous literature published by any other party before the date of patent filing, or by the date when you filed for the patent. We call it prior art. So if there is any mention of your invention, of what you are claiming to invent, in any literature, published literature of any kind, then it is not an invention from your side. It will not be treated as invention. Any invention that does not work. If you file a patent application and mention an invention and provide all the details, but when somebody tries to put it in practice, it doesn't work, your invention you would not be entitled to a patent, and if a patent has been given to you, the patent can be cancelled. Any invention that is not useful. So when we say utility patents, utility means it should be useful. Any invention that is not useful cannot be patented as a utility patent. So it has to be useful. It has to do something useful. Well, any invention that you disclosed before filing the patent, you cannot get a patent protection. Except in the US. In the US, inventors, by special law, if an inventor has disclosed his invention less than 1 year back, then he may still apply for a patent protection. Other countries are more restrictive and they may not protect any patent which has already been disclosed before the submission of the application. But time periods vary. In the US there is 1 year. So if you are an inventor and you disclosed your invention, the US gives you a grace period of 1 year. Other countries, maybe Germany, gives you 6 months. Other countries may not give you even 1 day. So one has to be very careful when you are disclosing, if you have disclosed an invention. So now, for example, the problem is like this. If you are in the US and you know about the law there, and the law says that if you are an inventor and you have disclosed the invention, but within 1 year of that disclosure you file your patent application, this patent will still be considered by the US Patent Office. Okay, you might be, let's say it was an invention, it passes all the tests, and the US Patent Office gives you the patent. But when you try to apply for this patent in other countries, if they get access to that disclosure which is before the patent application date in the US, then your invention will be rejected because it is already mentioned in prior art. Even though prior art was your own publication or your own public disclosure. So even though you may get a patent in the US, but your patent will be denied in other countries. New business models. New business models are only protected in the US. New way of doing business. For example, famous Amazon's single-click ordering. Single-click ordering. This new business model. And that is protected in the US only. Other countries don't allow business model as patents. Proprietary or secret information is disclosed. While proprietary or secret information of your company, if you keep it protected, can be your industrial secrets, intellectual property, industrial secret, intellectual property. But if you disclosed it by mistake, then that is no longer an intellectual property. It becomes in the public domain. But if you have kept it secret and if somebody steals it or obtains it illegally, then he is stolen your intellectual property and your intellectual property is still valid, you can go after him. And so on. We will, of course, cover many more issues related to each and every type of intellectual property where what all you need to be able to prove in order to be able to get the intellectual property, and also what are the usual reasons why your intellectual property applications may be denied or may not be enforceable. Trademarks, service marks which are not protectable. Well, normally trademarks is intellectual property right. So if you create, if your business is using a brand or a trademark, it will be protected by, according to the trademark law of your country or a state in the US. But what type of trademarks may not be protected? Trademarks which are confusingly similar to other registered trademarks. So if you have a trademark, you have an option to get it registered with the appropriate authority in your country or in the region. If you submit a trademark for registration that is very similar to another existing trademark, registered trademark, then your trademark will not be accepted for registration. And even if you keep on using this trademark in your business without registration, anytime the owner of the registered trademark wants to challenge you to stop using the trademark, he would probably succeed. Trademarks that you registered, but you stopped using them more than 2 years back, these trademarks are not protected. So if you have a trademark and you stop using it for more than 2 years, then it goes to the public domain. Trademarks showing natural objects in natural state or realistic. So trademarks cannot be natural objects or in natural state. For example, a tree, picture of a tree, photograph of a tree cannot be a trademark. And picture of an animal cannot be a trademark. It's realistic. But an animated picture of an animal can be a trademark. An animated picture of a tree can be a trademark. A modified picture of a tree could be a trademark, but not an object in the natural state cannot be trademarks. Generic words from any language cannot be trademarks. So any word or words which have a natural meaning in any language of the world cannot be used as a trademark. So in other words, trademarks you can say trademarks are made up words, have to be made up words. They should not exist in the dictionary, and so on. There are many more aspects that we are going to discuss later on. So intellectual properties rights, there are different intellectual property rights. We have talked about patents, we have talked about copyright, we have probably talked about design, we have talked about trademarks in this overview. So they are all different intellectual property rights, but they have some common aspects. And let's look at this common aspects. So let's look at the picture of the lamp shown on the screen. And if you look at this, and what is it? Is it a subject for a utility patent? Yeah, it is, right? It looks like a very utility type of a lamp. The lamp can be turned to any angle, so it's a utility. It can be put on any ledge. It's a utility. So you can apply for a utility patent also for this. But it's also a design, isn't it? It also has a design, so you can also apply for a design patent. So you can apply for a utility patent. You should apply for a utility patent. You should also apply for a design patent. Or you can apply for a design patent also if you want. What about copyright? Here the picture of this lamp, the image, the brochure, the catalog, the slogan that you use. Yes, that can be protected by copyright. So the picture of the lamp is copyrightable. So for the same product, we have seen you could have these three rights you could obtain. And if you could use this lamp as a trademark, you would use this lamp as a trademark, and then you could get a trademark also on it. So the same one single product, you could apply, you could obtain 4 different intellectual property on it if you so desire. Of course, while for copyright there is no cost involved, for trademark there is cost involved in obtaining a trademark. But you could have an unregistered trademark and then there won't be any cost involved. But for design patent and for utility patent, there are costs involved. So as a business, you have to decide that for the product that you have, for example, lamp, should you apply for a utility patent? You should, otherwise it's going to be copied and you'll have a copy in the market very soon from China. Or you could have should you apply for design patent also? Yeah, there's a design aspect involved in it. Design means that part of this design, that part of this product which has no utility function. Maybe the shape of the light, the bulb, maybe the contours of the legs of this lamp. Probably we could look at it from a design, so we could get a design patent on that. And if you wanted to make sure that nobody uses this picture for any purpose other than you, then you could also go for a copyright. You will get a copyright protection. And this brings us to the complexities involved in developing your intellectual property strategy for your company. When you make a product like that, we have shown, you have to decide which of these intellectual properties rights you want to protect. We said copyright you can protect very easily, no cost involved, but for the remaining 3 there are costs involved. So you must decide whether it's worthwhile going for the intellectual property protection. Books are copyrightable, of course, but the titles and character names in the book can be protected by trademarks. Books are copyrightable, but titles and character names in the books can be protected by trademarks as trademarks. For example, if you wrote a book and one of the characters was Funny Joe, then you could, and if you are intending to take out a series of books, series of books on that issue, or series of novels on the issue, where you are Funny Joe, you want to keep it as your own character, then you have to go for trademark for Funny Joe, and maybe do other things for create, try to capitalize on the Funny Joe trademark in other ways. So yes, your book is copyrightable, but characters in the books could also be protected by trademark. So again, the same product you can involve more than one intellectual property opportunity. Now let us look at what is a commercial organization's concern about intellectual property. Why would a commercial organization be interested in intellectual property? Or what are their areas of concern? Of course, the first logical thing is protection of the intellectual property assets. If you have created something new, you have made an improvement in your business process, you have made an improvement in your manufacturing process, you have some confidential data in your company, you want to protect, yes, protecting the intellectual property assets. So a commercial organization would want to know what are the intellectual property assets it can protect, and then make a decision which of these assets they want to protect by which intellectual property method. By utility patent, design patent, copyright, industrial secret, or trade secret. So which intellectual property right you want to take on that asset. Another concern for commercial organizations is avoiding infringement of other companies' intellectual property rights. Each business organization wants to avoid infringing other intellectual property rights because there might be legal penalties involved, or the other party may sue for damages if we infringe the intellectual property. Sometimes this infringement is, you can say, unplanned. For example, avoiding infringement may also cover issues of, let's say you have an industrial process, you're manufacturing something, and some of your engineers come up with an improvement idea on how to modify this process to make it more productive or produce a better quality product. So they come up with some improvement and you implement the improvement. Unknown to you, that improvement actually is protected by a valid patent. So if the patent holder finds out, he's going to sue you for infringing his intellectual property or the patent. So every organization would want to know what all it can do to avoid infringing other people's intellectual property rights. So we'll discuss this in detail in subsequent modules of this program. Another concern for organizations is providing for intellectual property indemnity provisions in your contracts. You buy products, you buy services, you buy software from other companies, and you pay for them. You pay a fair price for them. What if that product or the service or the software infringed somebody else's intellectual property? Third party intellectual property. That third party, if they find out, and when they find out, they might sue you and say that you are using their intellectual property without their permission. Of course, your claim will be that the contractor gave it to you or the supplier gave it to you, but it's like dealing in stolen property. You're using somebody's stolen property. That contractor had no right to give you that intellectual property. It belongs to somebody else. So what we do for that is we make sure that in any supply, technology related supply or service contract or consultant contract, we put down an indemnity clause in the contract whereby the contractor or the consultant agrees to indemnify you for any claims related to infringement of intellectual property or alleged infringement of intellectual property that may be brought against you while you are using the product or service the contractor has provided. So providing for indemnity provisions in contracts. So we want to try to know what type of indemnity provisions we should put in what type of contracts. as a business entity. Another interest of organizations is to clarify IP ownership provisions in its contracts. Well, what happens? You may hire a consultant to advise you on certain aspects of the product or the service or improvement. And he sends a team, the team works with you, and they come up with the improvement. And you implement the improvement and you pay the consultant. But this improvement, if this improvement represents an intellectual property right, or some intellectual property has been created in this process, who owns this intellectual property? You have user rights. Intellectual property owner, who is the consultant or the inventor, has given you a user right that you can keep on using this because you paid for it. But the consultant is actually the intellectual property owner because he invented it and he can go ahead and sell it to others. So we have to make sure that we write down in these contracts, including employee contracts, provisions related to who will be own the intellectual property that has been created during the service that has been provided to your company. Again, details are many. We'll discuss them later. Another commercial organization's concern is implementing procedures that ensure any unintentional intellectual property infringement does not become evidenced in organization. Well, every organization tries to ensure that they do not intentionally infringe anybody's intellectual property. But that is not sufficient. Sometimes unintentional infringement may take place. In such cases, this point number 5 talks about what all an organization can do to make sure that evidence will not be created that you infringe somebody's intellectual property. Another concern an organization has is to ensure that they are doing the due diligence related to 2 to 4 above. 2 is avoiding infringement of other people's intellectual property, and 4 is clarifying IP ownership provisions, and 5 is implementing procedures that ensure any unintentional infringement does not become evidenced. So we need to perform due diligence. So an organization wants to know what are the due diligence it must perform to make sure that 2 and 4 above will not cause negative impact on the organization. Another important interest of commercial organizations concerning intellectual property is profiting from intellectual property disclosures or others where the right has expired or is due to expire or lapse. Remember the intellectual property right. It's a right that is given to the inventor for a period of 20 years as for a patent, and other periods for design, 10 years for design and other periods. 20 years, 10 years pass, and then these intellectual property comes in public domain and we can use it and profit from it. Many times, even after 20 years, there's a lot of value left in the intellectual property. For example, pharmaceuticals. And one can copy the drug and sell it in the market at a huge profit, even after 20 years. But there is other ways also that the right may expire. Intellectual property right may expire before 20 years. Those could be where the intellectual property has been challenged and the patent has been cancelled, or certain maintenance and other activities have not been performed which are essential to maintain the intellectual property right. So organization wants to know how to profit from intellectual property disclosures. And another concern intellectual property organizations will have is to how to create awareness in research units of intellectual property issues. So make sure the research units and your production units are aware of intellectual property issues so that they can protect the organization's interest. Next in this overview, we are going to consider IP dispute resolution summary. You know, when an IT dispute happens, which means somebody claims infringement of his intellectual property by somebody else. That is could be one. Then we have to work out the solution for that problem, right? The first thing we must point out is that the patent litigations are very expensive. Especially in the US, they're very expensive. They're expensive everywhere, but in the US, they're particularly very expensive. May run into hundreds of thousands of dollars, if not millions of dollars. So the negotiated settlement is usually the norm. Most of these disputes will get settled through negotiated settlements. When we are thinking about settlements, there are various strategies one can follow or certain point that one we have to make sure that the settlement must cover. One is settlement without admitting liability of infringement. The alleged infringer would want to make sure that any settlement clearly mentions that even though he is paying some money as a settlement, he is not admitting liability of infringement, that he is not admitting that he has infringed, because that may have other consequences for his business. Another thing to think about is the settlement may include also the right to use the intellectual property in future. So when we settle for an infringement claim, the infringer would also want to make sure that included in the settlement is that he buys the right for intellectual property use in the future. So that also from the first point, he can also say he does not accept liability for infringement, but can always explain that the payment is being made for right he has acquired to use this intellectual property in the future. Another thing to worry about during settlement is that this settlement must give you indemnity or release from prior infringements, known and unknown. What sometimes happens is somebody sues you for an alleged infringement. You may settle. But then what may happen after some time is that the intellectual property owner may find out other things that you might also have infringed, and then he sues you again for it. So therefore we make sure that when we make any settlement, we must write down in the settlement that this settlement will release the alleged infringer or your organization from any known and unknown intellectual property violations of the past, so that no new cases can be brought against you. Sometimes the settlements are made such that, if relevant, it allows both parties to use each other's designated intellectual property. That as a part of settlement strategy is that each party will give some of his intellectual property and allow the other party to use it as an exchange. This way, again, we are not accepting any liability for infringement. Details of all these strategies and more will follow in subsequent modules that we're going to discuss in these programs. What about the government's interest in intellectual property? what is the interest of the government as far as intellectual property rights are concerned? Well, the government interest is in facilitating national development. Basically, what the government is doing is trying to make sure that the intellectual property rights and the laws are such that they will facilitate national development in the nation, manufacturing, service, business development in the country. And we see that in the US. From time to time, the intellectual property rights have been modified, including, in recent years to facilitate more rights being given to the inventors, tighter protection of intellectual property from infringers and so on. Another interest the government has that it wants to give the intellectual property rights such that national research and development and innovation is encouraged. These are three things: national research, national development, and innovation. Three things essential for economic progress. So the intellectual property rights must be such that research is encouraged, new product development is encouraged, and innovation is encouraged. Government will also want to try to protect the interests of national businesses through its intellectual property system to the extent allowed by TRIPS agreement or the various treaties that the government has subscribed to within the limitations of those treaties. And many governments, especially in the developing world and also in the developed world, their concern is about protecting the rights and interests of citizens. And the rights we are talking about here is for right of citizens to get a fair price for the products. That somebody should not use it as a monopoly and charge very high prices, especially when these monopolies are foreign owned. The interest of the government is that their citizens should get products and services at affordable prices. The government's interest is that counterfeit goods should be identified and removed from circulation, because the counterfeit goods, what they do is that sometimes they may also be bad quality goods and unsafe goods. And while we are trying to protect the interests of the citizen, the government is thinking about intellectual property, intellectual protection opportunity. That is, the intellectual property belonging to the citizen, that we want to try to protect that also. Also, governments are interested in protecting national traditional knowledge, especially in developing countries. And that is done through system of prior art and also geographic indicators. And protecting national geographic indicators. National geographic indicators are the quality indicators that are specific to your country. For example, champagne from certain areas in southern Europe, including France, or basmati rice from certain areas in India and Pakistan. Well, as we said in our introduction, importance of intellectual property for some countries is more, because for some countries it is getting more revenue for them. For example, US employment in intellectual property intensive businesses, as per the report of the US Patent Office of September 2016, suggests that the people working in intellectual property businesses were in this range. Almost 4 million people in patent intensive industries, 23 million people in trademark intensive industries, 5.5 million people in copyright intensive industries, and generally IP intensive, almost 28 million jobs. So for the United States, obviously, intellectual property is a major issue. 28 million people are working directly or indirectly related to intellectual property. And if you look at the international trade, IP trade inflows, we have data for 2013, which is a little old. International IP trade inflows. In the US, IP trade inflows, US got $329 billion in intellectual property related revenue from overseas. $329 billion. EU got $122 billion of revenue from the world for intellectual property. Japan 32 billion. Switzerland 21 billion. Canada 6 billion. Korea 5 billion. South Korea. Singapore 2 billion. Taiwan 1 billion. And China 1 billion. So you see US, for US obviously the intellectual property is a very important part of the trade. The $320 billion in revenue inflows because of intellectual property aspects. And Japan, Europe is second, 122 billion. So for some countries, this is very intellectual property is a very important issue. Now, if you look at the intellectual property trade comparisons, intellectual property is in which business area? There's more intellectual property business. Patents, 45 billion. This 2013 data. Patents, 45 billion business. Software is 43 billion. Trademarks are 17 billion. Global trade. Film and music, 17 billion. Food and beverages, 162 billion. Intellectual property, including probably trademarks. Brands, 162 billion. And total IP revenue, intellectual property revenue, 129 billion in the US, 2013. Automobiles, 125 billion, automobile industry. Finance and insurance, 110 billion. IT goods, 108 billion. Aerospace, 105 billion. And total world trade, 2280 billion. $2.28 trillion. Intellectual property related trade. And if you look at the various patents held in various countries, as of 2014, USA 2.24 million, EU 1.96 million, Japan 1.71 million, China 0.9 million. Now Chinese 0.9 million, you must also remember that these patents, valid patents, there will always be duplication between them. That means a company that files a patent in the US may also be filing a patent in EU and may also be filing in Japan and China. So sometimes these Chinese numbers, for example, 0.9 million is not representative that these are Chinese, Chinese nationals holding these patents, but it's that the number of patents that were filed in China. And later on we'll see from a strategies point of view that if you are a patent holder, in which all countries you will go and file patents. Usually those countries where you have competitors and where your markets are there, so that you can it makes sense to protect the intellectual property in those type of countries. Now, IP aspects of data used for data analytics and artificial intelligence. One big field for the future is data analytics and artificial intelligence. So we also need to worry about what are the intellectual property related aspects. So summarizing those aspects, we could say, for example, this data is kept in databases. So database software. Now, database software has been around for a long time, but new technologies for processing data. So there can be some parts that could be subject to copyright. What about the data in databases? The data that is in databases, there is some factual data or facts of data like name, address, age. There's no intellectual property right in these because those are facts. name of a customer, day, address, age. Of course, if it was a customer database, then it will be trade secret. But otherwise, there's no intellectual property aspect. Data that is not in the public domain would be put in as trade secrets. And copyright data would be like data like photographs and so on. Equipment with inbuilt data. If we are selling any equipment and the data is built inside it, then we can apply for a patent. So the data will be protected by patent. But where the data is separate, then it has to find protection through other methods. And the challenge is a builder of a database or other data resource will have an interest in who owns and who will use it. So the challenge is, so when you are building a database, some of the data which will be there may be taken from other sources. And we have to worry about is who owns the actual data and what is the use to which we can put the data. Someone who may populate the resource with data provided in parts or others, we have to make sure that that data is legal, ethical, professional, and professional obligation to make sure that all privacy and other regulations have been met about the data. So now reviewing the various IP rights that are there. One is, of course, the area of patents. Most common intellectual property right that people talk about is patents. So patents come in three forms. One is what we call utility patents. These are the patents that have some utility. You have invented something and that thing is useful. Or design patents, where you design something. Design means it doesn't have a utility aspect, but it has an aesthetic aspect. And plant patents, exclusively obtained plants can be protected in the US, for example. So you can get patents for these. Another intellectual property is the copyrights. We've talked about that. Trademarks, trade secrets, geography indicators. Geography indicators, sometimes we can call it community intellectual property because they belong to a whole area of the community. For example, if we talk about champagne, so all the champagne producing countries in Southern Europe, they are the owners of the intellectual property, which is the word champagne. In this training program, in subsequent modules, we will discuss the relevant details regarding these topics and more. So we'll discuss all these aspects in detail in practical applicable detail with checklists, procedures and so on for everything. Our discussion will cover domain work procedural aspects, for example, of patents, applying for a patent, for applying for a, initiating a infringement claim and so on. So various work procedures, applying for a trademark, for example, domain work procedural aspects. We'll cover the legal aspects. We'll cover all the relevant treaties, laws, treaties, and contractual obligations that you may have to worry about or need to consider when you are making your decisions. We'll cover the systematic due diligence that needs to be performed for these processes. We'll discuss the dispute resolution mechanisms, claim preparations, claim analysis, negotiating strategies for disputes. And we'll discuss about decision support, data analysis and AI systems, and the intellectual property aspects related to them. And we'll also consider operational audit and organizational domain system maturity about intellectual property maturity of the organization. And then we'll also consider strategic aspects or the leadership aspects, that if you want to have leadership recognition in this area of domain, which is intellectual property, what all we need to do for organization. Thank you. And this brings us to the intellectual property background module, whereby we took you in top level, provided top level journey through the intellectual property area or the knowledge area. And these and other related aspects will be discussed in detail in following videos and study materials. If you have not already registered, you can do so now. And our registration email is regn@training.com, and this is a WhatsApp number. Or you can go online on this link and register for the program. Thank you. We assure you a rewarding learning experience. So we will take you towards becoming a professional, becoming a good performer in the area of intellectual property in your business or your personal interest in the area of intellectual property.